Hello.
Hello,
This
hello.
meeting is being recorded.
How's it going, Jody?
I'm fine. How are you?
I'm doing well. Thanks for joining. We'll let people trickle in for a couple minutes, and then I'll basically just pass the torch over to you and let you do your thing.
That sounds good.
All right. Where are you based out of again, Jody?
I'm in Atlanta.
Oh, nice. We got a bunch of Atlanta folks. Trying to think if anyone hears Atlanta. Not yet.
Okay.
So what's the genesis of Red Clover, the name?
Two parts. The Clover is the intersection of data strategy, data privacy, and digital marketing, which were the areas that I wanted to focus on when I started it. And then it's also a little bit of a play on Red Hat software. I just like how those three words go together. Red is big and bold. Clover I just described. And then at the time, I felt like you needed a thing at the end. So advisors sounded good.
Uh,
What's funny is most people chop the advisors and just say Red Clover. So I actually need the other word at the end.
yeah. No, that's cool. I see that with law firms a lot. Like something something law, and then they
I know
just
you always feel bad for whoever's last. Sorry, I guess you're not as special and important when your names have been chopped off.
yeah. All right. It's 11:03, so we'll kick it off. People might trickle in after this. All right. So yeah, Jody and I touched base, maybe it was like a month ago, just around this concept of getting more like substantive educational pieces in here. Jody is the founder and CEO of Red Clover Advisors. She does Red Clover Advisors. You can do a better intro than I can about you all, but it's data privacy consulting. They touch a lot of different things. She mentioned kind of like the marketing piece as well, but they're a privacy consultancy firm doing all things related to scaling businesses, and of course like regulatory law in the U.S. and abroad. So she's an expert on all things privacy, and I will let her do our. What we decided on was essentially an update on U.S. privacy law. I think that's because there's a lot of stuff going on. I did a lot of privacy stuff, I guess, in-house when I was doing product law for fintech companies, and I just remember it was like at the time when all these states were enacting new laws. Now it's like this crazy mosaic of state law, and unfortunately, probably no federal law coming. But maybe you have an update there. But anyways, without further ado, I'll let Jody talk a little bit about her consultancy service, and dive into a state privacy update.
Wonderful. Well, hi everyone. And it looks like this is kind of meeting style. And I feel like I saw someone potentially even come off camera. I am all for that. If you want to join the party and the conversation, by all means, feel free to do so. As Brian said, I'm Jody Daniels. I'm based in Atlanta. I'm a privacy consultant. I'm not an attorney. And we help companies comply with privacy laws. We're going to focus on the US today. But the reality is what I had in mind is to kind of showcase really the what you need to do to comply with these laws, as opposed to sort of the academic, let's break down the kind of boring scoping parts of them, if you will. So what we are all about is actually helping do that. We're helping companies figure out what it is that they actually have to do, and then think of it as the operational. Someone actually has to do the long list of things. So with that being said, here's a little bit of what I had in mind. I actually think it's really important to understand why privacy matters, and thinking about the kinds of clients that you might be working with, why and where privacy might show up. Then talk about some of the laws and the key requirements. There's a long list of requirements. We could have a multi-day session covering all of them. I'm going to summarize them into some of the big key themes. We're also finding a lot of AI governance either showing up in privacy laws or privacy teams or privacy, whoever's been anointed privacy needs to own that part. So I had some thoughts about how to kind of blend those pieces together and then just try and wrap it up. So with that being said, you know what? It helps if I actually share my screen first. So it just dawned on me, I am going through slides and I didn't actually share my screen. I've just sent a request to share. Should be good to go. Okay, now let's try it again. Awesome. So you'll see my beautiful little picture here. Here's my agenda that I've just described, and here's my very pretty trust slide. So why does privacy actually matter? Well, customers care. Whether you are B2B or B2C, customers care. And for right now, there are still humans making decisions. I will be honest, I really hope the humans continue to make the decisions and AI agents don't make all the decisions. But with that being said, you can kind of pick almost any study, and it's between 70 to 80% of people. These stats in particular are focused on the US, but they really care about privacy. I actually, if you, I would love to connect with all of you on LinkedIn. Over the weekend, I posted an interesting post that I was trying to look at a variety of different AI tools. And so in looking at that tool, the very first things I was trying to figure out is what are their privacy practices, what are their security practices, and do they use my data? Now I'm in the B2B space trying to figure that out, and the multiple highly recommended places, none of them had what I was looking for. That didn't make me as a business feel good. This applies to B2B tech, B2B services, and in the B2C space. If any of you here today have ever answered, I prefer not to answer, you've chosen PayPal or an Amazon wallet or an Apple Pay instead of giving your personal information, or you made up your information, you did all of that because you didn't trust how the company was going to do it. So it shows up in the B2C spaces as well, which means it matters. It matters at the beginning, anytime someone is being asked to provide personal information, all the way through whatever the product or service is. Of course, marketing, everyone here has received some form of marketing, to then, you know what, I don't like you anymore, and to the end of your potential relationship with said company. That was your very fast trust journey, because Brian only gave me a really short period of time here, and there's so much to cover. With that being said, some companies do the right thing at the very beginning, at the outset. They just have strong values and they want to put the customer first. A lot of companies also say, oh no, it's my data. I get to do whatever I want with it. And as a result, some companies pushed a little bit too far. And as a result, we have laws. There's not one size fits law for everyone. Wouldn't that be lovely and nice? Some of the pieces overlap. In the United States, we do not have a comprehensive federal privacy law. Are we going to get a comprehensive federal privacy law? I don't think anytime soon, unless what I call it, it's a political dart. Regardless of which side of the aisle you are on, both sides actually care about privacy, but they can't agree on some of the mechanics. Multiple times, a privacy law at the federal level has made its way up, and then it died for a couple big reasons. One, private right of action. And then two, do the states preempt the federal law? Well, on the next slide, you're going to see just how many states we have, which makes this preemption piece a lot harder. And so what has happened is we have a patchwork of state privacy laws. But if any of you are familiar or have any healthcare companies, you might have had to deal with HIPAA. Of course, individually, if you've ever gone to a doctor, you've likely dealt with HIPAA. We have a long list of other privacy laws: text messaging, email, phone calls, direct marketing, all kinds of other privacy laws. And then globally, the gold standard is GDPR. GDPR is the General Data Protection Regulation. That particular law came into effect in 2018. It is actually 7 years old. It's going into first grade maybe. And there's the EU version. And then when UK had Brexit, it basically just copied it. The UK has tried multiple times and considered amending. It hasn't really come forward. So at the moment, they're pretty similar. Our friends to the north in Canada, they have their own privacy laws. And globally, there's more than 120 plus privacy laws, depending on where you are. But today, we're going to talk a little bit more about the states. If you like privacy and you think this chart is fun, I encourage you to check out the IAPP. IAPP is the Information Association of Privacy Professionals. In the privacy universe, That's our association. We have one big privacy association, and that is IAPP. They put out this chart. Now, here's a few challenges with this chart. First, anything in green is signed. So the kind of lime green going on here means it's signed. It doesn't mean they're all effective. We're almost all effective. We have 4 states left that aren't quite there, but we're getting really close. Gray is what was introduced this legislative season and didn't make it. So I'm in Georgia. Once again, they tried. I still have no privacy rights here in Georgia. And blue is, it's still going in this legislative season. Light gray, they had nothing going on this year. Well, what is a little bit of a misnomer is this is considered what's called comprehensive state privacy law. If any of you deal with children, there are some now separate children's privacy laws at the state level, in addition to COPPA, which is at the federal level. And COPPA at the federal level actually did just get an upgrade. So if any of you have to deal with children, I highly encourage you to pay attention to the federal COPPA, and then you need to find kind of your respective states where they are. In Washington state, which is gray here, they actually have a very strict health privacy law. It is broader than HIPAA. You could be in the supplement business, maybe the fitness business, the yoga business. You could be selling Advil, but you're targeting and you figured out that Jody or Cookie123 bought the Advil and then you target me. That might be health data. It's very broad. If anyone here has any clients or companies really broad in the health space, you might need to pay attention to the Washington law. And within each of the states, they're all a little bit different. Some of the states cover children. Some of the states cover health. Some of the states cover B2B. Some of the states cover employee. Actually, only California includes B2B, employee, and consumer. Not to be confused because its name is the California Consumer Privacy Act. But the word consumer means you and I buying too many things, or maybe just me on Amazon, consumer. Number 2, an employee. You have any employees in California. And number 3, B2B, which means you're a B2B company, you're reaching out to another B2B company. That personal information, Jody at redcloveradvisors.com, that email all by itself is personal information. As you can see, growing patchwork of complexity. A lot of different pieces that are happening. You might say, well, who manages any of this? Who enforces it? It depends. And I told you I'm not an attorney, but that is the classic answer. In some states, it's the attorney general. In most states, it's actually the attorney general. In a few states, they have a separate agency. Texas has a separate agency, and they are going after some really big companies right now. And they're also going after companies in the data broker space. Connecticut is going after a few companies kind of publicly, and they also put out a lot of reports. Here's what we're seeing. Here's what we're really interested in. Oregon also has an attorney general, and they put out a lot of reports and frequently asked questions. And the one I wanted to share a little bit of information and a couple examples in terms of enforcement is in California. California has their own enforcement agency. It is 40 plus people. They are continuing to hire all the time, and they are really moving forward in their enforcement. Now, one thing I want to clarify, we do not know everything that these states are doing. We only know what they put out. There are a lot of inquiries and letters that happen behind the scenes, which means if you only go to what the news has, you won't get the full picture of how active each of these states are when it comes to privacy. And for anyone who's in the B2B space, we see this show up a lot in sales. Remember I shared my example of over the weekend, I was trying to find some cool AI tools. There's a lot of other B2B companies evaluating each other. And so privacy and security shows up in the contracts. There are a few big settlements that happened from California, and there's this is one of the more recent ones, but there's sort of some similarities in some of the prior ones, and I can comment that. Healthline is one of the most recent ones from California. Before Healthline, we had one from Todd Snyder, and before Todd Snyder, we had Honda. And in prior years, we've had DoorDash, we've had Sephora, and we've had a couple others. There are some key themes that they care a lot about. Every state cares a lot about ad technology and cookies. And so I have some slides that I want to talk about with cookies and ad tech to help you be able to prepare for what it is that they're really looking for. When it comes to ad tech, this is something that anyone can see on the outside, a lot of it. They can tell if you opt out, did it actually work? They can tell if you were trying to have someone opt in, did it actually work? They can tell what your privacy notice says, and that's one whole universe, but they can also tell, does your privacy notice cover what it needs to related to cookies, and cookies are tied to ad tech. Here's a few of the issues that happened here. In Healthline in particular, they were sharing medical data. This is also kind of a no-no at the FTC level in a bunch of other states. But it doesn't have to be medical data. This could be just other personal information that might get shared. Maybe you're not in the health space, you can still apply this elsewhere. There's something called global privacy control. This is multiple states. It's basically a signal at the browser level. You can all go download this right now and be able to have all pixels blocked at the browser level when a site honors and listens to it. You, the consumer, put the signal on. It only works when the company's listening. And in this case, they didn't listen to the signal. And I see 2 items in the chat. I just want to make sure that those are questions or any other things. Maybe my screen. Oh, the map didn't work well. Oh, I'm so sorry.
Well, it's actually, I don't know if it's I don't know if it's just a problem with the map itself, but it shows like the dark green for passed legislation and then the lighter green for signed, but
they're all signed. Maybe that's the problem. They're all signed. There's nothing passed that's not signed yet. So they all should have been light green.
Got it. Okay. All right.
So on the legend, it might have been messy, but on the actual map, they're all signed right now.
Okay.
Hopefully that clarifies anything. There's nothing cool and exciting that's in a past zone that hasn't been signed that's on the map as of today.
Got it. Okay.
I can find you some old maps where it exists that way, but right now we're nothing new and exciting at a comprehensive level came through this legislative season so far.
Okay.
But that is a standard link and you can go all the time. So Mike, thanks for sharing that link. Cookie banners. Everyone here has seen a cookie banner. Fun fact, depending on where you are, you actually don't need a cookie banner. Cookie banners are not required here in the US. I have some slides, we're going to talk a little bit about that, but if you have a cookie banner, you got to have it correct. If you have a cookie banner in the United States, they want accept and reject. They want symmetry and choice. They want you to be able to manage your settings. And in this situation, and almost all the other cases, they did not have it properly. One of the other pieces is overall, anytime you give data to a third party, a processor, a service provider, a vendor, pick your flavor name, you need a contract in place with it. The same is true in ad tech. No matter how complicated ad tech is, you need a contract with it. They didn't have all the right contracts that they needed. Privacy notices need to actually say what you're doing on the site. These privacy notices did not actually say what was happening on the site. A few other issues. So, or kind of, some of like the takeaways rather, I suppose, is sensitive data. Sensitive data is very unique by state. For any of your companies, the very first step is to understand the kind of data that you're collecting and the volume and where they are and the volume that you have in that state and your revenue, because they're not all created equal. Some states do it on volume based on the number of people in that state. Some states have no minimum threshold, like in Washington, the Washington My Health, My Data Act doesn't have a threshold. And in California, many companies get in scope because of their revenue. It's $26.6 million now. It used to be 25. They increased for inflation. How kind. So, and then GDPR globally, there's no threshold. One person, you're in scope. Which means you need to know which states you're in, and the state is based on where the data of the person is, not where you, the company, are. You could be headquartered in Georgia and your customers are across the country. You have to look at it across the country. And the reason that's so important is the definition of sensitive data is different. Some states have sensitive data as opt-in. Some states have sensitive data as opt-out. Sensitive data could include a broad range of health data. It could be financial data, but it's not all financial data. What I find is a lot of times companies have a security definition of sensitive data, and it's not the same as a privacy definition. race, ethnicity, religion, that all might be sensitive data. You got to understand where you are to know if it's sensitive or not. You have to have the right consent experience. It really matters. No dark patterns. Dark patterns are misleading. Anyone ever been trying to buy something and everything is all pre-ticked, or it's really tiny print, or it's really hard to go and do? That's all dark patterns. No dark patterns. No better font, big colors, big size, none of that. Global privacy control, got to make sure you have that on. The contracts are really important. Do not sell and share. This is a really fun and interesting one. Do not sell and share is a very unique requirement that came out of California. A couple other states have followed. Almost all ad tech is considered a sale of data. You might say, but that seems strange. Why? Because if you have a Facebook pixel on your website, you give Facebook data from the website, you have a targeted ad, yay, you're happy. Facebook also uses that data for everybody else. Therefore, the explanation is you have sold the data to Facebook because you share data to a third party and the third party gets to use it for other purposes. And the definition under California is for monetary or other valuable consideration. The other valuable consideration is that Facebook gets to use this data for themselves. This concept is beyond just ad tech, which is why we go back to understanding the data and what you're actually doing with it. And we'll talk about that a little bit more. And so it's really important that this is just all operational. Now, there are so many requirements in these privacy laws. This is one way of how to look at them. This is our proprietary framework. We break the privacy laws down into these big buckets. For our conversation here today, we're going to focus on just a few. We're going to focus on the data, privacy notice, a little bit of privacy rights, and the cookies part. That is often where companies start. And from the outside, everyone can read your privacy notice. Everyone can see your cookies. And you can't really get those right if you don't know anything about the data you have. And they can also test the privacy rights process. So what do I mean? Well, first, when we talk about data, you need to know what kind of data you have. In our opinion, data inventories, knowing your data, is the foundation of a privacy program. Why? It helps you do all these things. It helps you comply with privacy laws. And guess what? Some privacy laws require you to have this. You can't really know your privacy risk if you don't know the kind of data and the people it's about. You can't really honor privacy rights requests if you don't know the kind of data and where it is and what you're doing with it. It's going to be really tricky to send all those contracts that I just said you have to have if you don't know which third parties you're working with. If there's an incident, you have data breach versus privacy incident. You got to know the difference. And of course, we want to make sure we're protecting our data because all of these privacy laws will say something about making sure you have reasonable security measures in place. Okay, so what is it that you kind of want to consider? What are some tips for managing the data part? Well, first is you have to understand what type of processing are you doing. Think about your company. How do you make money? What's that core business operation? And what's the kind of data that you collect? What are the kinds of people you collect data from? Do you collect them from consumers, B2B, employees? And what kind of data do you collect? And then think about how what we find is it's really helpful to use the same nomenclature. Meaning, are they subscribers, advertisers, patients, guests, travelers, teachers? What do you call the people that you're collecting data on? You want to be able to identify those people. And then the kind of data that you're collecting. So I said, what's your core business? There's going to be data there. How do you market and have sales activities? The HR and people aspects, a lot of companies want to include even if their employees aren't in scope. And then, of course, if your employees are in scope, you have to make sure you understand all of those processes as well. And there might be other parts of your company. Maybe there's customer support. Maybe there's analytics. And you want to be able to understand, I collect what kind of data from what kind of people. I do what with it, and I store it where. And that storing might be a third party, a vendor, a service provider. So then you're going to say, well, who are you, third party and service provider? I need to make sure that I can trust you. I'm going to have a contract in place. I might limit what you can do. Maybe some of you have done the same AI exercise that I have as you're evaluating. Wait, who are you, third party tool over here, and can I trust you? The other part is it's imperative to know the jurisdiction that is relevant for you, because that's going to determine the very specific privacy requirements that you have to do. Some states have specific charts and wording that they want in a privacy notice. Not all states have the same privacy rights obligations. Sensitive data isn't the same. Sensitive data might be opt-in versus opt-out. Some states want certain links and footers of websites. You have to know where you are and what data you are processing to be able to know exactly what it is that you need to be doing. All right, so let's move to cookies. Okay, I kind of mentioned a little bit about cookies, and here's some of the decisions that you have to make when it comes to cookies. Do you have a banner? Banner yes, banner no. You have to be able to honor that global privacy control. And if any of you here want to test it out for just yourself, you can go to global privacy control, go to the little consumer dropdown. It's an extension, put on the extension, and then you're going to be able to see what happens. Some states will honor you, some states won't. This middle, do not sell or share personal information, is a California specialty. That little icon is also specific from California. It is from the Attorney General's office, and you get two options. You can have that beautiful little circle checkbox thing with the words your privacy choices, or the link, do not sell or share my personal information. When do you need this? Pop quiz. If you are using ad tech, like targeted advertising, you very likely need this. Or you actually are sharing data to third parties for money, or sharing data to third parties and they get to use the data for themselves. Or an interesting fourth one, you share data with a third party and you have no contract in place. The default, if you have no contract, is that they could then use the data. If they could use the data, it might be deemed a sale or share under the California law, which goes back to know your data and make sure you have the right vendor contracts in place. Cookies have to get tied to privacy notices. One of the big findings between the different enforcements, Honda, Healthline, Todd Snyder, all kind of similar issues. Their whole cookie experience wasn't working right. They didn't have the right links and their disclosures weren't accurate. And then I just mentioned the contract part. Now, there's a whole other universe in the cookie world that I want to talk about too. And it's tied to if you have a banner. This is around digital pixel lawsuits that are going on here in the United States. I don't know if any of you are familiar with the ADA kind of WCAG compliance, accessibility compliance on websites. There's a lot of plaintiffs firms, they go after websites, they say you violated the law, you get a letter, now you have to deal with it. The same thing's kind of happening here using old privacy laws. The most common is one called CIPA, the California Invasion Privacy Act. And it is essentially the saying, you, a website, put a tracking pixel like a Facebook targeted advertising pixel on the website. It doesn't have to be Facebook, it could be others, but that's the most common. You put this tracking pixel on the website without my consent. That tracking pixel collected data from the website and shared it to a third party. You did all that without consent. That was eavesdropping. You therefore violated the law, paid this money. This is very popular. There's a couple other, you can kind of see there's wiretapping, pen, register, trap and trace, various versions of this. And so companies either ignore it and take the risk. They choose to go to an opt-in approach. And yes, they're also going after website chatbots. They're going after AI these days. They're going after anything that they can because it's just one more way for them to be able to make some money. If I go back to cookie banners, globally, they are almost always opt-in, but in the US, it's complicated. Remember I said there's no requirement in the United States to have an opt-in banner. The exception to that is kids, if any of you are targeting kids, and if you're targeting sensitive data, in which case health might be part of sensitive data. But most companies I work with, that hasn't necessarily been the case. So for the majority, it is not an opt-in requirement. Again, kids and sensitive data. Remember, sensitive data often includes health data. Otherwise, you now have to make some decisions. And there's a lot of companies who say, I don't want to deal with this pixel lawsuit stuff. I'm going opt-in. If they go opt-in, they lose the benefits of the marketing, but they lowered their privacy risk. If you don't, then you get the marketing, but you increase your privacy risk. It is a company decision of what you need to be doing. And they are so annoying annoying. They are totally like the trolls. I agree. Now, when it comes to all things cookies, this is not just a marketing thing, and I really want to emphasize this. I posted something the other day on LinkedIn, and someone responded saying, this is what is keeping CIOs up at night. It's pixels and cookies. The cookie team is privacy and legal. They need to know the requirements and then help say, here's the risks, here's the requirements of the laws, go. Marketing teams, web development teams, IT teams, who actually owns the cookie consent tool? I've seen everyone own the cookie consent tool. And then don't forget about ad agencies. I have also seen companies say, well, I outsourced it all to the agency. They have full reign. And then the company has no clue what is happening. That's not a good plan. If the agency owns it, fine. But the company is still responsible, because guess who is going to get in trouble by a regulator? The company. They go after the company. If I'm a lawsuit, I go after the company. Now, maybe you have great ironclad contracts to go upstream to the agency. Not really the best plan. We need the agency to be part of this conversation, and I see this over and over and over again. So find out who is going to be your cookie team, because that's the way you're going to be able to identify which requirements and what you're going to do from a business point of view. Then you set up your cookie consent software. Even if you choose no banner, you still need the software, because I have to be able to opt out. Under all the different laws, I get to opt out. And some laws have global privacy control, also part of cookie consent software. Some have do not sell requirements, and your software is going to help you there. But don't forget to test it. We see so many failed implementations. Once you get it set up and running, you test, everything is great. Also, don't forget that it's ongoing. Remember those agency folks that I was just telling you about? They're adding pixels all day long. Your IT teams might be adding pixels all day long. People might be doing new things. And as websites get updated, unfortunately, it's tech. And sometimes tech breaks, which means you've got to figure out the right cadence for you to keep testing this on an ongoing basis. But test, please test. So kind of to wrap up the cookie governance piece, you sort of need an overarching plan and program. In my beautiful universe, program would look like you know which laws apply. You figured out your setup. Are you opt in? Are you opt out? What is it all going to look like? You approve new pixels before they go on the site. You know who these pixels are before they go up on the site. You're doing some type of audit. You're reviewing it on a regular basis. You're tying it to the privacy notice, because all the laws say make sure you tell me what it is that you're actually doing in my privacy notice. We train the people who are part of this, and then we rinse and repeat and carry on a go-forward basis. And I see a question. Does using a third-party LLM and disclosing personal data of website visitors to the AI constitute sharing for monetary or other value? I figure it depends. It does depend, because it would depend on exactly what kind of data you're feeding it and what they get to do with it. So if you were to share, I don't know, a list of here's my 100 personal information names, and it went into a tool and they get to literally use the names to help, I don't know what they would do with it, but there's no limitations, then it very well might be that scenario and situation right there. Definitely, and it depends. Privacy rights. Cookies is a really big part of privacy rights, but the other part of privacy rights come from all the laws, and almost all of them have access. Tell me what kind of data you have on me. Right to delete. I don't like you anymore. Delete my data. Right to know, which is a privacy notice. Right to change the data you have on me is wrong. And a few others, and opt out. They vary by law, but what doesn't vary is you have to be able to receive that request. Our friends in California are really particular. They have a couple specific ways of how they want that request to be received. If you are online only, you get to avoid the 1-800 number. If you're not online only, you need a 1-800 number. Then you need an email or a web form. One of the really important pieces is regulators are using this process to go after companies. If they have a concern, they're actually having companies, they're trying to test out the process here to see did they get it set up properly, and are they even checking the inbox. In the Todd Snyder case, it was 40 days, and their comment was no one even noticed because no one was checking the privacy rights mailbox. You need a process that someone actually is going to manage, and you need a plan to be able to manage these. Maybe you're listening and you've never had a privacy rights request today. Great! You probably won't have a whole lot. You still need a plan. You still need it in your privacy notice. If your company and you've received a handful of them and it's starting, you have a process and it's going smoothly, wonderful. When you start to feel some pain about how long it takes to manage this, that's when you really are going to want to have some software to help you automate part of that process. In any process, whether it's manual to software, you still have to think about the communication, the who is involved in your company, which systems this is tied to. Remember, we started with data. Where's the data? You need to know where the data is so that when someone comes along and says, I want to delete my data, you know where it is. You also need to know which exceptions apply and what you can and can't be doing. And one of the important pieces, almost every enforcement action has dinged the companies because they did not train. The California law specifically says you must train whoever's responsible for privacy rights. So train whoever's responsible for privacy rights. The burden of proof is always on you, the company. It doesn't say exactly how to train them, but Susie in your company needs to know what to do, and you need proof that you trained Susie. One of my favorites when it comes to privacy notices. Okay, the whole point of a privacy notice is say what you do and do what you say. You need to know what's actually happening in your app, in your product, in your website for your employees so that you can write an effective privacy notice. California has some very specific disclosures. It's why you often end up seeing a chart if you've ever read privacy notices before, which I know everyone here has read them from start to bottom. It often, just a chart ends up being easier. It doesn't say a chart, it just doesn't have all the things. Others have certain disclosure requirements. Like if you list every state, Oregon wants to make sure you've listed their state too. If you don't list every state, you have to make sure that you have a process to be able to honor Oregon's privacy rights. And one of their fun, interesting ones is I could say, tell me the list of every third party you've shared my data with. That actually is a requirement under GDPR, which means global companies are able to respond to that one fairly easily. And Connecticut, I think, is the state that just amended its privacy law to follow the same kind of idea. So see, you have all these different states, and they're sort of like grouping. Oh, I like that part over there, and I like this part over here, and I'm gonna, add it to my little group. Now you get your privacy notice up and running. Awesome. Now you actually have to follow it. When the product team, the marketing team, someone comes along and says, I have this brilliant new idea and I want to go and do something with it, you have to make sure that they check the privacy notice first. Does it say whatever it is that you want to be doing? Either yes, okay, good. If no, can you make an amendment? It would be from there forward. You can't go backwards. There's no retroactive privacy notice. California also requires you update it at least once a year. It is a dead giveaway because you also have to have a date on that privacy notice. Mark your calendars, have a way to update the privacy notice at least once a year. So just a little bit on AI governance, because I see this coming up more and more for privacy teams. It's very similar to privacy. You need someone responsible for privacy, whether that's full-time, part-time, just someone who knows how to find the right resources, just someone responsible. There are many of the privacy laws that are including AI in it. California is one of them in particular, but there's several others as well. Someone needs to be able to have assessments. Much like privacy impact assessments, think of a risk assessment. Here's my shiny new idea, or I'm using sensitive data in some capacity. I have to have a risk assessment for privacy. You should be doing it for AI as well. So privacy and AI end up going really similarly together. A vendor evaluation. Oh, I have a brilliant new vendor I want to go use. Amazing. Who are you? What are your privacy risks? What are your security risks? What are you going to be doing with my data? Like the example that we had earlier, you're going to share personal information to an AI, to an LLM. What are you doing with it? Can I trust you? Can I not? Now, this conversation should expand beyond personal information because don't forget, right, we have company confidential information. This is really popular right now in presentation software. There's a lot in recording software, right? There's a lot of really cool, interesting AI tools, but if I put in some of my company confidential data, am I okay with this company over here using it? Who are you in the vendor universe? And you need to be able to understand. So kind of another way to think about this is if there's a brand new product or marketing idea or use case, HR scenario in your company, what is the project? What are the privacy risks? What kind of data is being collected? How do I mitigate? Burden of proof is always on the company. And every single one of the regulators cares a lot about how you made decisions. Showing your homework gives you extra credit. It truly does. It's an important piece to do. And what I hope I leave you with here is not just that there's this privacy thing over there or this AI thing over there, but that actually it should be part of the process. Because most companies, when they have a brand new idea, or a new use case, they always say, how much does it cost? How long will it take? Who are the people? Hopefully they're thinking, is there any legal implications? We want them to think about privacy and security the same way. And that's just getting the conversations happening into operations and on an ongoing basis. Which means privacy is not just the legal person's job or the privacy person's job or the compliance person's jobs or security person's jobs. It's literally everyone's job. If you remember my cookie team, there were a lot of team members and they all have a different role. Privacy is really the same way. Because as I started the conversation with how people care about their data, they care, can they trust the company, especially as more and more AI features are coming into play, or if you're in the space where it might be sensitive information for the person. It could be personal information, it could be financial information. I worked with a company in the pet space, and they said, and pet data, there's actually very little personal information. But for them, they know that for pet owners, their pet is like their kid. And it's incredibly sensitive information. So for them, it was all about doing the right thing. And there was a brand new startup, they don't even have a website yet. And they already knew how important privacy and security was going to be to their journey, because it is all about making that customer feel like they can trust you. I hope I've given you some tips for success. Where do you go? Someone has to own it, whether it's full-time, part-time, just someone to know how to find the right resources, and most importantly, know the data. You have to know the data in your company. My recommendation is think customer first. Employees need to know what it is that they need to know. Role-based training. Think about the people in your company. Is it marketing? Is it product? Is it HR? What is it that they need to do? If anyone's never sure, it's always just a good idea to ask. And I wish I could say it's going to stay stagnant, but if we were to do the same presentation next year, it will be totally different because there will be new privacy and AI laws. My next slides are just some resources for you. We know that this is complicated, and we try and create a lot of content to try and just help break it down. So I will share, you can go grab some information, and I'm happy to answer any other questions that I can.
Thanks so much, Jody.
Right on time, 2:44.
Yeah, thank you. It's rare to be a minute early on these things. I want to.
I try really hard.
Yeah, for anyone who wants to jump in with some questions, if anything popped up in your head while she was talking on any of these topics, feel free to chime in. Otherwise, if you do have questions after the fact, I can always forward them along to Jody.
Anyone have any other questions?
Anyone?
Hey, I just successfully unmuted myself. Hi, Sion. I'm a fractional general counsel, and your last example, I'm in the middle of a busy WeWork, I'm sorry. Your last example brought to mind just an understanding of price. I think somebody also mentioned this. So for the pre-revenue startup that is trying to think through its data inventory, let's say it's light, let's eliminate healthcare and, too many financial, like credit cards. Like, what would their estimate be for getting ready, or bringing in you all as like a consulting firm?
So I want to answer that question a little bit differently because the cost is super different, and I'd love to be able to have a follow-up. The way I would think about that is thinking about the parts of the business. What are the core business activities, and what kind of data? Because for some it's really complicated, and for others it's really simple. And right there is going to make that difference. Then think about the marketing and sales activities. And then think about, where is it going? Is it starting in the US? Is it going global? Because all of that changes really how much you actually have to do. I mean, we literally have a free Excel template, like just a blank piece of paper to think about. Okay, so I'm going to collect name and email and address. I'm collecting name, email, social security number. I mean, think about what it is that you're literally going to be collecting, and then what you're going to do with it. As simple as, I'm collecting this, and doing what with it out of the department is a great place to start. That information, if you talk to any person, are going to be the same questions to be able to help identify what you have to do next. Because the privacy notice is going to be one of those first pieces, whether you have to include just basic information, if you want to be forward thinking to include for California, or if you need to think globally to GDPR, that is level of complication right there as well. Your cookie consent software, there's free, really basic software to some software that's 20 bucks a month to some software that's a couple thousand a year. And most of them nowadays are based on volume to the site. So then if you have someone internally to be able to get the software up and running, then that's great. If you need support on how to set it up, that might just be a few hours of support versus a full implementation. So the most important things are the data that you're having. The other part to that is you have to know where it goes so you have the right contracts in place with those. Now, you might say, well, I'm working with Amazon. Great. You might be saying I'm working with Salesforce. Some of them literally have you download a contract and send it in somewhere. Others are you've accepted it automatically and you have no negotiating power. Others are you've hired an agency and they're going to own all the marketing. You need a contract with them too. Privacy notice, cookies, and know your data are going to be the very first steps to getting started. And so happy to chat more to help prioritize, but I wanted to give a little bit of a more vague answer to help anyone else listening to know where to start, because the level of effort just changes a little bit. Any other questions?
Sorry, my quick follow-up was, do you also act as designated DPOs for EU, UK?
Oh,
Based
good question.
operations?
We actually do not. So the DPO, for those maybe not familiar, it's a data protection officer. It is a very specific requirement out of GDPR. And with it comes all kinds of registration and, quite honestly, liability. So no, I have a wonderful collection of people that I refer to, and that's what they do. So I like to refer to those. What we do is the data privacy officer. So just like fractional, general counsel, we'll do fractional chief privacy officer or fractional data privacy officer, which is not the same thing as the DPO version over there. And here in the US, some states, now if you're big enough, you need to have that level. And I will say HIPAA has its own, and HIPAA has its own requirements, just like GDPR has its own requirements. And we don't do the HIPAA version either because they're so specialized and unique. We're hanging out in, again, much more similar to the general counsel version, where you're going to be able to tailor the level of support to what the company needs. And instead, I have referrals. Excellent question. Anyone
Amazing.
else?
Anything else? Anyone else?
Well, thank
Maria,
you so much for the opportunity. I really appreciate it. Like I said, I'm super active on LinkedIn. I'd love to connect. Brian, can we send slides to people if I PDF them to you?
Yes,
okay.
please.
Yeah,
Please
so I'll PDF and you can have these to your heart's content.
Awesome. Yeah. Any resources you want to send along that we discussed, please send, and I'll forward it to people in the Slack group.
Excellent.
All right.
Thanks
Thanks so
everyone
much,
for joining.
Jody. All right. See y'all.
Bye.